am a lawyer, but I am not necessarily your lawyer. The materials discussed in this podcast are for informational purposes only and should not be deemed legal advice. If you have a specific legal question according to your circumstances, then I encourage you to speak with an attorney licensed in your jurisdiction. Welcome back to another edition of Ag Law Today. We've got Tristan Bloomington back in the house from Bloomington, Illinois. Tristan, welcome back to the podcast.
Thanks for having me back. It's been so long.
So, Tristan, I know we're both sitting here on Illinois soil. We're both family and divorce lawyers. But why don't you introduce yourself again to our listeners, remind everybody where you are and what you do.
So I am an attorney who does divorce work. I do family law. That's my primary area of practice, but I also do criminal defense. I joke with people that if you're coming to see me, probably have had a bad day, unfortunately, but I'm here to help. I work at Meyer Capel, where I'm one of the shareholders. We have offices in Champaign and Bloomington, and I'm based in our Bloomington office.
So, Tristan, I am definitely not a criminal lawyer. I am nobody's call from jail. So tell me a little bit more about what drew you to criminal law.
My goal with becoming a lawyer was to get into the courtroom and to get as much experience in an actual courtroom as possible. And the original goal after law school was I'm going to be a public defender. And 2009 was a rough time to graduate and get a job as a public defender, as they were actually laying off a lot of people. And I wasn't able to find work right out of law school in that. So I went into legal aid, which gave me a lot of courtroom experience and some family law experience. I went on to finally live my dream of being a public defender for a while, and for reasons I don't need to get into, I didn't stick with that too long. And the jumping off point from there was to a family law firm. And I really honestly didn't expect that I would like it, because family law doesn't have that reputation amongst lawyers as the thing to do that's amazing and what you want to do. But it got me in court a lot. It got me a lot of experience that I wouldn't get otherwise as the low man in the totem pole at a firm doing other types of practice. And it got me a lot of client interaction, which is a lot of what being a public defender and criminal defense attorney did. It lets me help individual people, which is what I ultimately want to do as a lawyer.
Yeah, I have, well, it's a little bit of a different story, but I did not go to law school thinking I was going to do family law. I'm not a child of divorce, so I don't have that type of story. What led me to family law, I was just trying to pay rent in New York City, and a divorce came my way. I had a good mentor to handhold me. And there's a saying with lawyers that sometimes you don't find your practice finds you. And I feel that family law found you, Tristan, because I know you're a very good family lawyer. And like myself, I went to law school because I wanted to help people, and I didn't know what that was going to look like. But I think in family law, I think that there's a lot of need for some sincere help, for people during those transitions.
One of the things we talked about last time was advice to people who are going to law school. And if you do end up going to law school, don't be too worried about making sure you take the classes in the areas that you are certain you're going to practice in. I didn't take a single family law related class while in law school. Not a single one. I took a whole bunch of criminal law classes and I loved them. I took environmental law classes. I took elder law classes. I took classes based off of the professors that I thought I was going to enjoy, and that was helpful to my law school experience, and I don't think that it has hindered my abilities as an actual lawyer at all, that I didn't take that class while in law school.
Yeah, I agree. I mean, I think that law school, to your point that you said last time on the podcast, it really teaches you how to think and write like a lawyer. I mean, that's the important skill set. And no matter what direction that you decide to take it, it doesn't really matter if you have taken those classes. So to talk a little bit about farm divorces or just divorces in general. And, I think a lot of people are surprised, Tristan, that a divorce is basically a lawsuit, right? I mean, in Illinois, we call them petitioners and respondents. In New York, they're plaintiffs and defendants. But I think a lot of people are surprised that it's literally litigation. Are your consults and things surprised at that as well?
They are, and I think that they're surprised that it's a lawsuit, but it's not a lawsuit that lets them go in there and say, he did me wrong and he's going to be punished. It's not a lawsuit about who's wrong and who's right. It's more similar to a lawsuit between two business partners who have decided to wind up their business and they can't agree on what needs to be done. So they file suit and the court has to decide how to divide this business. And that's the attitude I try and give my clients for how we need to look at this. This isn't a vindication of establishing that he, in fact, was a bad husband. This is, he was a bad husband, sure, whatever. What are we going to do with the house?
I know. But Tristan, here's the thing, is that you and I both know that people sometimes enter into the divorce process and they're highly emotional sometimes. People are bringing in photographs and text messages or stories about how they found out their significant other is really gay. And none of these things really matter, right? But it matters tremendously to that person. So how do you manage that?
And that is probably the biggest struggle of being a family law lawyer, is setting clients' expectations and helping them redirect from what emotionally is most important to them, but realizing that the only thing the court is going to be able to do is protect them and their economic interests. And so I view my role a lot as the trusted sort of business advisor. Sometimes you just have to let your clients be heard. And so sometimes you say, okay, thank you for that. That helps me understand why you are reacting to these things this way or why you have that position. We're not going to be able to use that in court, but it does help me understand the history. But you have to, at some point, explain, if we go into court and we talk about that, the judge is going to shut you down and say that that's not relevant because it's not one of the factors that the court gets to consider in responding to it. I think it is perhaps ultimately a flaw in our system of justice that divorce is an adversarial process and a lawsuit, because it promotes that mudslinging and it promotes that us versus them mentality. I say it's a flaw in it, but I can't point to a system that is absolutely better. There are advantages to things like collaborative divorces and things, but you're right. It's a surprise to a lot of clients, and it's jarring when you get served with, a process server shows up and says, here you go, here's the divorce paperwork.
Yeah, I know. And I think that people are surprised. I mean, in the state of Illinois, it's public record. In states like New York, it's sealed, but that it's literally in the public record, right?
And people, I always have to caution some clients that they have to be careful what they put in that public record. I know of a person who was able to buy a house for a very low price because someone's marital settlement agreement said that they were going to list the house for $250, but they would accept any offer over $210.
Yeah.
Someone found that. What do you think they offered?
Yes, that's why those things need to be filed in a confidential attachment or something like that. So let's talk about just the general divorce process, Tristan. Let's start with the consultation. What are the things that are discussed and that maybe aren't discussed in that initial consultation?
So I try and do my consultation in about the span of an hour. And I begin by explaining that everything they tell me is going to be protected by attorney-client privilege, that the goal for me is to get an understanding of what their marriage is, including financial information and then information about any children that they may have that I need. And I call it that sort of like the foundational information I need. I say it's like building a house. I need to see how the house was built from the foundation to the roof, and then I will talk to you about what we can do to tear that house down, which is probably a terrible analogy in some ways, but sort of what we're doing. And I spend most of probably the first 30 to 40 minutes of the consultation just asking questions to understand what's there. And I regularly have to tell people when they'll say, well, what do I do about this? Or can I get that? I don't know yet. I still need some more information. So my consult is primarily a fact-finding mission for me to figure out what we're talking about. And then I'm going to try and spend that last 15, 20 minutes talking through goals. What's important? Do you want to keep the house? Do you not want to keep the house? Is your goal you don't really care about money, you just want to walk away from it? Is this going to be a custody fight? Figuring out what the areas of dispute are going to be, and then I will outline a plan for how we can try and accomplish that goal, or if the goal is unrealistic or impossible, explaining why that's not a realistic goal and what could actually happen. And then at the very, very end of my consults, after I've answered as many questions as I can, I will then walk through, here's how you hire me, here's how much it's going to cost, here's what my fees are.
So what if somebody in that initial consultation doesn't really know for certain if they want to get a divorce? Maybe they're considering legal separation. Maybe they're thinking about reconciliation. They're asking about this thing called mediation. What are your thoughts there? If someone's just unsure that they want to get a divorce.
So if someone asks about legal separation, I usually tell them I don't think that there's any good reason to ever do a legal separation in the state of Illinois, other than potentially if for religious reasons you're uncomfortable with the idea of a divorce. I find legal separations to be all the work of the divorce without all the benefits. For other people, when they're not sure, I like to use that as an opportunity to say, well, that's fine. And I'm a divorce lawyer, so I'm certainly not the person to ask, how do I save my marriage? I don't know. Go to a counselor. I'm the person who can help you get out of it. And I'm not the person who sees a lot of healthy, good relationships. I'm a guy who gets people coming in here usually at the worst of times in their relationships. I like to walk them through what could happen. And also if they think, well, I might stick it out a couple years, what things they can be doing to improve their positions to get the things that are more important. So if someone's here and they're not sure they want a divorce, but they think if things don't improve, if he doesn't become a better father, they're going to leave. Okay, well, if that's what you're going to want to do, here's the evidence that I'm going to need to really have a strong case for making sure you get the custody you want. So not manufacturing evidence, but here's how to document those things better for me going forward. And if it's going to be a financial thing, here's how to better position yourself financially so that you can get the things you want. I love to talk to people about mediation. I love mediation. If people can get things worked out in mediation, I don't make as much money, but I am not by no means unhappy at that fact, because I've got enough clients that I'm happy to walk people through mediation. I like telling people, hey, if you're thinking about mediation, you still want to hire an attorney so you can go into mediation educated. A mediator is just going to facilitate an agreement between the two of you. If you don't know what your rights are, if you don't know that maybe you're entitled to half of the marital residence, you might not demand that you get that in mediation. You might agree to let the other person keep the house, not realizing that you had some rights there. So mediation, I think, goes better if both parties have attorneys, because then you have two educated people. The worst mediations are one person has an attorney, the other person's representing themselves, and they're convinced that they can get full custody and they never have to pay child support, when any attorney would advise them that that's never going to be the case.
So what if somebody is like, yes, I would definitely want to get a divorce, but I have all these questions. Perhaps you represent the spouse who wasn't really working, or perhaps, the other spouse is the one who is a farmer or the business owner. And there's just a lot of questions about the finances. What's the next step after the initial filing and all of that?
So I do discovery in almost every case. And discovery is the formal process where I send a demand that I be provided with a list of documents that I need to figure out the financial things. And so I'm at a bare minimum going to usually ask for 2 years of bank records, 2 years of tax returns, 2 years of pay stubs. If there are specific businesses that I'm aware of, I'm going to ask for those business records. Some of it's a fishing expedition to find out if things exist. And then if I find out they exist, I may issue more specific requests. I'm also going to send what are called interrogatories. Interrogatories is just a fancy legal term for, hey, answer these questions for me. Illinois conveniently has standard matrimonial interrogatories that I will regularly use in what I'm going to call more basic cases, but you're not required to use only them. There are some advantages in the way you count the number you're allowed that are going to help guide me in understanding those things. And so I'm going to tell my potential client, I know you don't know those things right now, but we're going to find out that information through the discovery process. And if they still won't comply, so the next objection from the client is often, well, he's not going to give you everything. Yeah, I understand that. And that's where the subpoena power of the court comes in, and you start saying, okay, where's he bank? We'll just get his bank records directly from the bank through a subpoena.
Yeah. And for our listeners that are maybe a little confused about what a subpoena is, how would you describe it?
So a subpoena is the court has the power to issue an order to a business or a person to require them to produce something. In Illinois, we go through this sort of absurd notion that they're going to show up to a deposition to answer questions, and they're also required to produce documents for you, but you can waive their appearance at showing up as long as they mail you those documents in advance. But it's just a legal way to require someone to provide documents to the court. You can also subpoena someone to come and testify. You can subpoena someone to come and answer questions under oath. And the nice thing about practicing law in Illinois is I don't need to get a judge to sign that subpoena. Any attorney in the state of Illinois can issue a subpoena on behalf of the court, since we are technically officers of the court.
So let's just say people are relatively cooperative, people are exchanging financial documents, but then there's still some questions about how much things are worth. Like, for example, farm equipment. Maybe you came back with an answer to an interrogatory with a list of farm equipment. Would you get that appraised, or what would you do, Tristan?
Well, that's going to depend on what it is and how much we're talking about. If it's a $200 chair, we're not going to get a $200 chair appraised unless my client tells me, no, it's a $10,000 chair. Because paying the appraiser $50 to appraise that chair to come back and say it's worth $250, just that doesn't make sense. It's also going to depend on what my client says. So if they respond, we've got all this business and the business is worth, this piece of equipment is worth $50,000, and my client says, we spent $700,000 on it 2 years ago. Yeah, I'm going to get that appraised. That's almost certainly something where the cost of the appraisal is going to pay for itself in the increased value my client is going to get by being able to establish that $50,000 was a super, super low ball. Other times, my client might say, no, I don't want to get it appraised. He says it's worth $750. I think it's probably worth $850. I'll meet him in the middle. And then I may just send something to opposing counsel saying, look, for purposes of settlement, we're willing to agree that the value of this is this number. But I don't always get things appraised, and that's really going to be a fact-dependent situation. With the example you gave of a client who doesn't really have any knowledge, I'm going to be more inclined to get appraisals in those circumstances. But two people who are on similar footing, if they think they know, I'm generally going to trust their valuations.
Yeah. And then, similarly, if there's real estate, maybe get an appraisal, maybe there could just be an agreement as to the valuation. of farmland or perhaps residential property. So let's just say that stage is done. Walk me through the negotiation process. How does that usually work with divorces, or what are the different methods that negotiation could take place?
Well, and it's going to be different in every case. And one of the values of having a local attorney is they're going to know the best way to negotiate with the opposing counsel that you're dealing with. So depending on who my opposing attorney is, I may call that attorney and say, hey, here's what I think's going on, and talk it out and have a conversation and see where we end up. That's unique. I don't always do that. Some communities are more phone-based than others. I'm primarily going to start with a conversation with my client, get a document I prepare called an inventory of assets and debts, and then a distribution of that inventory of, you're going to get this, they're going to get this. Put that together and then send a letter to opposing counsel that says, here's all the valuations we've agreed on. Here's how we think they should be distributed. What do you think?
So Tristan, I'm curious on your thoughts on this. With farm families, I have had multiple clients come to me, and they have been very hesitant to even break up the farm, and they're wanting to keep the farm intact and to shift their relationship from a marriage to really being more of a business relationship. Have you seen this work?
So I don't have nearly the farm experience that you have, but I can say that the experience I do have with farmers who are getting divorced, who've got that family farm where maybe they live there in the same places where they work, and that farm's been in the family for generations. That's probably the most emotional attachment to assets that you're going to get as a family law attorney. It's not just a truck. It's the family land. And no, I've never seen this idea of two people who were married who are now divorced still sort of co-owning something and working it together. It's a recipe for disaster, in my opinion.
Yeah, I think it can work in limited situations if the relationship is right, but I think that there really needs to be some thought process about, like, what happens if this doesn't work? What's the exit strategy? How are things going to be valued at that time? What about inheritance issues with farms, or not just with farms, like maybe just business owners in general, family business owners that are maybe just, they're wanting perhaps a promise that the farmland is going to go to their kids upon their death. I mean, have you seen that issue come up in any of your negotiations?
You do see that a lot with inheritance. Wow.
Say it 3 times really quickly, Tristan.
Just start over with me speaking English now. When someone inherits, when someone inherits something, it is by definition under Illinois law not marital property. And so it's not going to be something that goes to the spouse in a divorce under most circumstances. But I always tell people, look, if you are about to inherit some property or some money, go meet with a divorce attorney and have a plan in place for what you can do to make sure that that money stays your non-marital money. And I'm surprised at the number of financial planners that I discuss this with who have no idea what they need to do when they're investing this money, or they're figuring out what to do with it to protect it so it doesn't get converted into marital property. Because it's very easy for non-marital property to lose its identity as non-marital property and become marital property. And that's important because when the divorce happens, that sounded cynical. If the divorce happens, the court divides the marital property. The court doesn't divide the non-marital property. You get to keep that non-marital property. But if you take that non-marital property and you put it into a marital account with your spouse's name on it, you've just turned that into marital property. And you're not going to be able to back that out under most circumstances years later without some really high level forensic accounting. And even then, you may have ruined things. So in those circumstances, it's really important that you document things like crazy. Make clear this chunk of land came from my father when he passed away, and I've titled it in my name, and I've kept it separate from all the other chunks of land that we have. Otherwise, I'm sorry, go ahead.
Oh, no. And speaking with the buckets of property, right? I know in Illinois, it's non-marital property and marital. In New York, it's called separate and marital. One of the reasons why I love prenups is because, parties can enter into the marriage and to be very clear on what is in those buckets. What are some advantages can you see, Tristan, for farm families or perhaps families with agribusinesses or food companies in having a prenuptial agreement before they get married?
So one of the difficulties if we're having this divorce and we're fighting about whether or not this piece of land is marital or non-marital is that documentation. And a prenuptial agreement is the gold standard of documentation to show, hey, we didn't intend for this land to be marital property or community property, or I forget your New York term, any of the other properties that are subject to division in a marriage. And so having a prenuptial agreement can make very clear, look, this was something that was mine before we started, and thus it's non-marital. Or I've seen sometimes people will say, it's anticipated upon the passing of my father that I will inherit the following, and we will at that time treat that as non-marital. And sometimes you can also add to that prenup or a separate agreement an idea that for tax purposes, we may still title it jointly, but we're still going to treat it as my non-marital property, which Illinois law would allow. But it's just the best form of documentation. Now, it's only good documentation if it's done correctly. And in my opinion, a prenuptial agreement where only one party has an attorney representing them is not done correctly. It's not going to be good. And it needs to have some specificity. It needs to have a list of the assets. It needs to have a list of the debts. And it needs to very clearly explain what all of these things are. Otherwise, there's the risk that the court's going to look at it and say it's unconscionable. And if it's unconscionable, it can't be used by the court at any point. And so you've wasted all your time writing a piece of paper that's not worth the paper it's printed on.
Yeah, I refuse. I will not do a prenup if the other side doesn't have an attorney or refuses to get a lawyer. And I think some of my clients are surprised that there needs to be full financial disclosure at that point. I mean, unfortunately, sometimes, but not always, that's the first time the couple is actually having a very real conversation about their income and their assets and their debt. And I'm just surprised, Tristan, at that, because I feel like people sometimes do more due diligence when they buy a house than before they walk down the aisle. But I feel like it's a very important step for a financial partnership before people get married.
Well, like you, I will not do a prenup if the other side's unrepresented, because I think I'm just charging my client money to produce a piece of paper that essentially has no value. I will outright tell my clients, look, if they can't afford an attorney, you need to give them money to go hire an attorney to review this. Otherwise, all the money you're spending for me is worthless. And I don't know if your experience is similar to mine, but most of my prenup clients, they'll come to me 12 to 9 months before they're going to get married. We'll have a discussion about everything they're going to need. I will surprise them. I agree with you. They're surprised at this idea that they need all these financial documents. I will go over in great detail everything they need. And then I won't hear from them until about a month before the wedding when, oh my God, I need my prenup done. And I'm saying, well, I still need this document, this document, this document. And so I've started, I hope, doing a better job when I first meet with clients who are considering a prenup, explaining that it's not just I can just write it and the two of you sign it. It's, I need to get documents, and it's a garbage in, garbage out situation. If I get everything I need, I can write you a good prenup that it's going to protect your records, but I'm going to need time to prepare it right. And I'm going to need time to get it to the opposing attorney, who's going to need time to review it and go over it. And so if I don't have those things and a decent draft of it about a month before the wedding, it's going to be a problem. And you do not want to be the guy who has to say to your client, we can't get this done before the wedding, so you have to decide, do you want to get married without a prenup? Or do you want to be that person who says, I don't know. No, this prenup is that important to me, so we're going to go have a ceremony with our friends, but we're not legally going to be married until afterwards.
Yeah. So I tell people, and there is not a court case that says this is just my rule, that prenups ideally should be signed 3 months before the wedding or before the wedding invitations go out, just because I feel like the closer you get to the wedding date, the more duress that there might be, the more pressure, the more likely I'm going to make like a mistake, at the last minute. I cannot stress enough, like, for people to think ahead. Do not wait to the last minute on any of this.
And if you are considering a prenup, when you go meet with that lawyer, it's going to be a lot easier if you have an idea of, hey, here are my assets, here are my debts, here are the value of those assets. And if you have an idea of what your soon-to-be spouse has as well, that's going to be useful. It's not necessarily required, but having that idea, but then also having an idea of what it is you want that prenup to do for you. Is this a prenup to protect assets that are potentially non-marital? Okay, great. That's one useful aspect of a prenup. Is this a marriage where one party is going to have a lot more money than the other, and we want to avoid a huge alimony or maintenance obligation? Okay, that's something. I'm going to need to have more income figures to do that. Is this about estate planning stuff, where we need to make sure that the spouse isn't the one who inherits things upon their death, but it needs to go to maybe children of a previous marriage or a brother or a sister? Have an idea of what it is, and the attorney should be able to walk you through all the different aspects of it. But any attorney who just tells you, yeah, here's my standard prenup form, is not doing a good job, because they can do different things, and it need to be tailored to your specific financial circumstances.
So Tristan, for our listeners who are like, all this sounds fine and dandy, Tristan and Carrie, but I'm already married, right? So what are your thoughts on postnuptial agreements with farm families or families that have agribusinesses and food businesses?
The difficulty I always find with postnuptial agreements is there has to be consideration for a postnuptial agreement. A prenup, the consideration is that you're going to get married. And consideration is this legal concept that, a contract is only enforceable if there's a bargain for exchange. You don't get to hold someone to a contract unless there was a meaningful exchange of money for services or money for property. In a prenup, the consideration is we're going to get married. A postnup, there has to be some form of consideration because you're already married. And in my opinion, that makes postnuptial agreements not as valuable as prenuptial agreements. And the value of the consideration, there's not a lot of case law testing what that consideration is. Most of the case law that deals with it is, okay, we were married, I filed for divorce, we signed this postnup, and I agreed to dismiss my divorce. That appears to be sufficient consideration. The rest of it, what is and isn't, it is not as clear. But you may find yourself in a situation saying, I want a postnup, and if you won't sign it, I'm going to leave you. That's a tough situation. That's not a conversation I'd ever want to have with my spouse.
So Tristan, I've done more prenups than I can count. And I can tell you that I have only done one postnuptial agreement, only one. And I've had so many occasions where perhaps we weren't able to get it done prior to the wedding, and that person just decided like, hey, we're just gonna like get married and come back to you in a week and do the post-up. No, it almost never happens. I don't know about you, Tristan, but I feel like there's always high hopes before the wedding, but I feel like after the wedding, where's the negotiation power? I mean, I just feel like I completely lose it at that point. So unless it's 100% voluntary, which the one that I did was, it just doesn't really usually happen.
Like you, I've only ever done one post-nup, and it was someone who they were getting a divorce, and they decided they figured out a way they could work it out. And we almost even turned I think a marital settlement agreement, turned that into a post-nuptial agreement and said, here's what it's going to be if we get divorced, but we're going to dismiss the divorce. But we already spent a bunch of money on attorneys telling us what our divorce is going to look like if we get a divorce. I mean, I think you run the risk of them being found unconscionable because of that. It's not as clear of a negotiating circumstance anymore, because in theory with a prenup, you have that power to say, no, I won't marry you. With that postnup, you don't clearly have that power to say, I'm not going to do this.
Yeah, I know. Okay, so to boomerang back to the world of divorces. So let's just say somebody does have a prenup or a postnup, and I do want to note that at least in the states I practice with, prenups can't talk about kids stuff, right? They're not going to talk about custody or allocation of parental responsibilities. It's not going to address child support. So how does a prenup or a postnup affect the divorce process?
So yeah, you're right. I don't think that there is a state that allows a prenup to address children issues, because it just goes against public policy, because ultimately we want courts making decisions for children based on the best interests of the children, and what a post or a prenup says 15 years before, it may not apply at that point for children. With the financial aspects of it, if you have a good prenup, you're going to file for your petition. And if that prenup is then presented to the court and the other side doesn't dispute it, that's essentially going to stop all of the fighting about financial stuff. You have removed, let's say it is a divorce with there are children, you've removed 50% of what was there to fight. And it's now just a matter of, depending on the quality of the prenup, incorporating that prenup into a judgment of dissolution of marriage, saying it's the order, or redrafting the prenup as a marital settlement agreement and a judgment to go along with it. And then the parties can spend all of their time negotiating or mediating or fighting about what's going to happen with the children. And so you can really save yourself a ton of attorney's fees and potentially get the same result. But what it really buys you is just some level of certainty that that's what's going to happen.
Yeah, and of course, some prenups don't, or they reserve certain issues like spousal support. That might be completely resolved or reserved for the time of the divorce, and that's fine, right? So at least the other issues are dealt with, and then we could look at the income of the parties and determine if spousal support is appropriate. So Tristan, to close, I wanted to ask you a question about COVID. We're still in the COVID world. So what has been the biggest silver lining for you during the last 6 months or so during this pandemic?
One of the nice things is here in the county where I practice primarily, McLean County, the courts were very quick to say, we've got to figure out a way that we can keep functioning even though it's not necessarily safe for us to be in there. And part of the issue for us was the criminal courts had to keep going and family law was less important. So we have been doing a lot of court via Zoom, and it has been, well, not everything can be done via Zoom as efficiently. Status hearings via Zoom are fantastic. I don't have to pack up my bag, walk to the courthouse, go through security, walk up to the courtroom to have a 5-minute hearing. I can sit down at my desk, turn on the Zoom thing, have that 5-minute hearing. have a memo to my file and a letter to my client drafted and sent out before I would have even made it back to the office previously. And so it's freed up some time to be able to do things like that. It's also dramatically improved my health because I'm cooking and not going to restaurants as much anymore. And that's been really nice to learn that cooking skill and focus on realizing that I'm good at it and I enjoy it, and it makes me healthier to do it that way.
Yeah, I agree. Especially, I'm a little jealous. McLean County certainly has their act together with all the Zoom hearings, and I think that for me as an attorney, it was disappointing for me to have the court just kind of shut down for a little while. So it's been nice to say, okay, even if we're back in shelter in place, can the court system continue to function? And I think with the use of video conference technology, like with Zoom, that opens up a lot of opportunity. And Tristan, I think I was in court with you about a week or so before we were even in shelter in place. Is that right?
Yeah, you're right. That was one of the last real court hearings I had. And then we were in court again on that, I think the last time over Zoom.
Over Zoom, the world woke up in a very, very different place. So Tristan, to close, where can folks find you? Do you have contact information, a website?
So my website for the firm is meyercapel.com. I think last time I mentioned that I have gotten off social media, but I do actually have an Instagram, I remembered, devoted to my two cats, and I refer to them as the Attorneys at Claw, which is my Instagram handle, the Attorneys at Claw. We are the only claw firm in the world that I'm aware of. And one of the things I did during COVID is I have a transom window over my home office when I was working there, and it now says Bullington, 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 Attorneys at Claw, because I'm a crazy cat person and I'm unapologetic about it. But for official, if you want to hire me or you have questions, meyercapel.com will be able to get you everything you need to get a hold of me.
Well, Tristan, it's been a pleasure. Thank you for your return to the podcast.
Thank you for having me. It was a pleasure.